So students, now we are going to start a new chapter, that is law of contracts, and all the contracts act are based on a particular act, that is Indian Contract Act 1872, and there is a statement that all contracts are agreements, but all agreements are not contracts. After learning this entire chapter, you will clearly understand what does this statement means. Now we will look into what is an agreement. We can say that there is an agreement when one offers a particular thing to another person and there is an acceptance from that another person, then we can say that there is an agreement or there form an agreement. And Section 2E of the Indian Contract Act 1872 defines the term agreement, and it defines as every promise or set of promise with a consideration is an agreement. Every promise or set of promise with a consideration is an agreement. Look at the example. Here, A promises to give his book to B, and B in return promises to pay ₹1,000 to A. So there is a promise. Promise means A promise to give his book to B. And there is a consideration. What is a consideration? B agrees to pay ₹1,000 to A for giving his book to B. So there is a consideration. So if there is a promise or a set of promise with a consideration, we can say that there is an agreement. Now we will look into what is a contract. And Indian Contract Act Section 2 subclause H defines the term contract, and it says an agreement which is enforceable by the law is a contract. So an agreement which is enforceable by the law is a contract. And in the same act, Section 10 says about certain conditions when an agreement can be considered as a contract, or the certain conditions to be satisfied to term an agreement as a contract. Which are the conditions? Let's see which are the conditions. Okay, the first one is there must be two parties. We will consider all these conditions with the examples we just discussed. So the very first condition is there must be two parties. If we consider the example we discussed, there were two parties. A and B were the parties. And the parties must be competent to enter into a contract. That means both the A and B should be in a sound mind. Persons are capable to enter into a contract. And the third condition is there must be a lawful consideration. The last example, ₹1,000 is a lawful consideration. And the object of the agreement must be lawful. In the last example, the book was the object and it's a lawful thing. Then there should be a free consent between the parties. Free consent means there should not be any force or outside force. A should agree to give his book to B, that should be in a free consent, and at the same time B should agree to buy that book with a consideration of ₹1,000, and that also should be at a free consent. Then the last one is the agreement must not be one which has been expressly declared to be void. There were certain transactions were declared by law as void, so a transaction should not come under that category. If it comes under that category, that entire transaction will be treated as a void one. Now we are going to consider whether the moral obligation or the legal obligation which makes an agreement as a contract. whether is it moral obligation or legal obligation. Let's check it out with a landmark case, and this is very important. It's Balfour versus Balfour, and it's all English cases, okay? And the facts of this case is that a husband and a wife went to England for vacation, and during the vacation, the wife fell ill, and the doctors advised her to be in the bed rest, and so she has to remain in England for her treatment. But when the leave period was over, the husband has to return to their native place, that was Ceylon, and he returned. And but before returning, he promised that he will send rupees 30,000 every month for her treatment. He sent the amount that promised 30 pounds for some time, and later stopped sending that 30 pounds because some misunderstanding between the husband and wife. So what the wife did? She sued him to recover the arrears, but the court dismissed that case, stating that there is no legal obligation in the agreement. That means the agreement between the husband and the wife is only contains a moral obligation, not a legal obligation. So we can establish, by this case law, we can establish that to consider an agreement as a contract, there must be a legal obligation between the parties. And we even define the contract as an agreement which is enforceable by law. So it is not the moral obligation, it's a legal obligation is the particular aspect should be present in an agreement to term it as a contract. Now we are going to learn about the terms offer or proposal and acceptance. And the very first step in the formation of a contract is that there should be an offer or proposal and there should be its acceptance. So now we will find out what does it mean by offer, or how the term offer is defined in the Contract Act in 1872. And section 2 subclause A of the Act defines the term offer, and it says when one party express his willingness to do or not to do something, we can say that there is an offer. So when one party express his willingness to do or not to do something, we can say that there is an offer. And the person who is making the offer is known as offerer. The person to whom the offer is made is offeree. And the intention of the offer should be to make a legal relationship between the offerer and offeree. Now we will look into what does the term acceptance means, or how the term acceptance defines in the Act. Section 2, the clause B defines the term acceptance, and it says that when the consent is given by the offeree to the offerer, we can say that there is an acceptance. So when a consent is given by the offeree to the offerer, we can say that there is an acceptance. So by saying yes, okay, or just clicking, in the modern way we are just clicking I accept. So all these are different kinds of or different forms of acceptance. So in conclusion, we can say that if there is an offer and if there is an acceptance of that offer, we can say that there forms an agreement. Now, the other important thing is that this offer and acceptance should be a definite one and a clear one. That means if the offer or acceptance is not definite, not clear, then it will not form a contract, and if such form and the contract formed will be treated as a invalid one. And the other important thing is that this offer and acceptance must be communicate with each other. The person making the offer, the person accepting the offer should communicate with each other. Then only they form a valid agreement. And this communication can be through email or any kind of electronic forms. Anyway, there should be a communication. That is a mandatory condition. And can we say that an offer get lapsed? Yes, an offer get lapsed if it is withdrawn by the person who made the offer. And at the same time, an offerer can revoke the offer before it is accepted by the offeree. And now we are going to discuss a very important question of law, that is, can an offer be made to the world at large? And if can made to the world at large, can we call it as a general offer? And what do you think? Is it a valid one? And what about the communication? Is communication of acceptance is necessary in a general offer? We will discuss all these questions. Okay, we will discuss all these question of laws with a very important landmark case, that is Carlyle versus Carbolic Smoke Ball Company. This is also an English case. And in this case, the facts are like this. The company was the manufacturer of the medicine smoke ball, and this smoke ball is used for the treatment of influenza. And while making an advertisement, the company offered a reward of £100 to anyone who got influenza again after using this medicine, this small smoke ball, continuously for 15 days. And the company also made a commitment or in the advertisement that the company has already invested £1,000 with Alliance Bank to make rewards if any such kind of situation arose. And here the Mrs. Carlyle, seeing this advertisement, Mrs. Carlyle bought the smoke ball medicine. And Mrs. Carlyle started to use it as directed in the advertisement. But Mrs. Carlyle got a fresh episode of influenza even after using this smoke ball medicine for 15 days. So what she did, what happened then? She filed a suit claiming that reward of £100. Here the company refused her claim, and the defenses raised from the side of the company were like this. Like the company said that it has no intention to create a legal obligation with anyone through the advertisement. The company said they made the advertisement only to boost the sale. And the company also argued that we cannot consider the advertisement as a offer. And an offer made to the public as general or to the entire world cannot be a valid one. And there is no any acceptance of the offer, and Mrs. Carlyle have not even communicated the company that she accepted the offer. So there is no any legal binding. These all were the defenses raised from the company side. But court rejected all these arguments raised by the company and allowed the claim of Mrs. Carlyle and allowed Mrs. Carlyle to claim her £100 from the company. Now we will discuss what all were the findings of the court. The court remarked that depositing £1,000 in the Alliance Bank by the company, by the medicine company, itself shows its willingness to enter into a legal relationship with anyone who accepts the offer. So there is a willingness by depositing £1,000 in the Alliance Bank by the medicine company. The second remark was an offer can be made to the world at large, and we can call it as a general offer and it's a valid one. Then the court said, in general offer cases, there is no need of communication of acceptance. Merely fulfilling the conditions said in the advertisement itself is an acceptance of the offer. So the court at last declared that yes, Mrs. Carlyle is entitled to claim her £1,000 from the medicine company.